Hello, this is Michael O'Brien, and welcome to another video in our series on foreclosures in Oregon. Today, we're going to dive deep into the judicial foreclosure. If you're an Oregon homeowner concerned with staying current on your mortgage, then this series may be for you. Let's get into it. In a different video, we talked about the basics of foreclosure, and I pointed out that in Oregon there are two different ways that a foreclosure can occur. It could either be a non-judicial foreclosure, which is an out-of-court process, or a judicial foreclosure, which is an in-court process with the judge. A judicial foreclosure is started by the filing of a complaint in the court of the county in which your real property is located. You can see in the document I'm showing you now, right on the front, it says Circuit Court of Oregon for the County of Washington. It indicates the plaintiff in the suit. That's the lender or loan servicer who started the lawsuit, and the defendant in the suit. That's the homeowner, and often other individual or entity. Once this document is filed, it then has to be served upon you and all other defendants, which brings us to tip number one. The complaint does not have to be personally served upon you. Most of the time, the complaint will be served upon you by a private individual hired by the loan servicer, knock on the door, confirm you're the defendant, and hand you the complaint. But what if you aren't home? The law allows a complaint to be proper if it is served on anyone else who lives at the residence and is over the age of 14. I've raised 4 children through their teen years, and this terrifies me, okay? The complaint, which threatens to take away your home, is legally effective if handed to a 14-year-old who lives there. Sure hope they remember to give it to you. Now, there is a small safety net. If the complaint is not served on you personally, then they have to mail a copy to you as well. Once the complaint is served, the clock starts ticking. And that brings us to tip number 2. You only have 30 days to act. Once a complaint has been served, you have 30 days to respond to the complaint, or the lender will win. 30 days goes by pretty quickly. I've met with hundreds of people going through a judicial foreclosure, and on average, it's about day 25 before they come in and meet with me. 3 weeks with the home being threatened before I even meet with the client. Now, I'm not passing judgment here, it's just an observation. I think the thought of losing a home to foreclosure is so terrifying that people, they just freeze while they're trying to process what's going on. Now, luckily, once hired, we can almost always gain some additional time before we have to act on the client's behalf. But what act must be taken in those 30 days? Tip number 3, you must file paperwork with the court. It's not enough to call up your lender and start negotiating. It's not enough to call the lawyer who represents the lender. It's not enough to send a letter to your lender or the lawyer. Nope, before the clock runs out, you must file paperwork in the court where the lawsuit was started. Most of the time, that paperwork is an answer to the complaint. Now, this answer is where you get to tell your side of the story, but it must be done in a legal format, and it must address all of the allegations made in the complaint. Sometimes a motion could be filed instead of an answer, but it's a pretty advanced legal process, which brings me to tip number 4. Get help from a lawyer. Foreclosure defense is not a do-it-yourself process. The lender is represented by a lawyer whose job it is to take away your home. Go hire your own lawyer. A foreclosure defense lawyer is going to meet with you to go over the facts of your case, review documents, and analyze whether you have any defenses that can be raised. And that lawyer will be prepared to file that motion or answer with the court. If you do nothing, the plaintiff wins the lawsuit, and the final result is number 5, the sheriff will sell your home at public auction. Once the plaintiff wins, the judge will order the sheriff to hold a public auction of your home. You'll get roughly 30 days notice before the sale, and the successful bidder has a right to possession of your home 10 days after the sale. So by the time the sheriff has the order, you've got about 45 days to move out. As I've said many times before, the earlier you get started exploring your options, the more options exist. If you call my office, the number below, mention this video, my staff will set up a phone conference with me at no charge to you, where we can chat about